Executive Power. Section 1. The executive power shall be vested in the President of the Philippines, and it is the power to enforce and administer the laws. NEA versus CA. The scope of power is set forth in the Constitution, specifically in Article 7. However, executive power is more than the sum of specific powers enumerated in the Constitution. It includes residual powers not specifically mentioned in the Constitution. Marcos versus Manglapus, 1989. The prosecution of crimes appertains to the executive department, whose responsibility is to see the laws are faithfully executed. Webb versus De Leon. But the President cannot dispose of state property unless authorized by law. Enforcement and administration of election laws is the authority of the COMELEC, but the President cannot create public office without valid delegation from Congress and subject to the constitutional rules. Executive power shall be vested in the President of the Philippines. In the presidential system, the presidency includes many other functions than just being executive. The President is the symbolic and ceremonial head of the government of the Philippines. Executive immunity from suit. Rules on immunity during tenure. 1. The President is immune from suit during his tenure. Number 2. He may be filed impeachment complaint during his tenure. Article 11. The President may not be prevented from instituting suit. Sullivan versus Makasair. 4. There is nothing in our laws that would prevent the President from waiving the privilege. The President may shed the protection afforded by the privilege. Sullivan versus Makasair. 5. Heads of departments cannot invoke the President's immunity. Gloria versus CA. Rules on immunity after tenure. 6. Once out of office, even before the end of the 6-year term, immunity for non-official acts is lost. Such was the case of Joseph Estrada. See Berna's commentary. It could not be used to shield a non-sitting president from prosecution for alleged criminal acts done while sitting in office. Estrada versus Desierto. Note, in David versus Arroyo, the court held that it is improper to implead President Arroyo as respondent. However, it is well to note that in Rubrico versus Arroyo, the Supreme Court ordered the respondents, including President Arroyo, to make a return of the writ. You respondents, President Macapagal Arroyo, are hereby required to make a return of the writ before the Court of Appeals. Reasons for the privilege. Separation of powers. The separation of powers principle is viewed as demanding the executive independence from the judiciary so that the President should not be subject to the judiciary's whim. Public convenience. By reason of public convenience, the grant is to assure the exercise of presidential duties and functions free from any hindrance or distraction, considering that the chief executive is a job that, aside from requiring all of the office holder's time, also demands undivided attention. Executive privilege. Briefly, in simplest terms, it is the power of the President to withhold certain types of information from the public, from the courts, and from Congress. How invoked? Invoked in relation to specific categories of information. Executive privilege is properly invoked in relation to specific categories of information and not to categories of persons. While executive privilege is a constitutional concept, a claim thereof may be valid or not depending on the ground invoked to justify it and the context in which it is made. Noticeably, absent is any recognition that executive officials are exempt from the duty to disclose information by the mere fact of being executive officials. In light of this highly exceptional nature of the privilege, the court finds it essential to limit to the President the power to invoke the privilege. She may, of course, authorize the executive secretary to invoke the privilege on her behalf, in which case the executive secretary must state that the authority is by order of the President, which means that he personally consulted with her. The privilege being an extraordinary power, it must be wielded only by the highest official in the executive hierarchy. In other words, the President may not authorize her subordinates to exercise such power. Senate versus Ermita. It follows, therefore, that when an official is being summoned by Congress on a matter which, in his own judgment, might be covered by executive privilege, he must be afforded reasonable time to inform the President or the Executive Secretary of the possible need for invoking the privilege. This is necessary in order to provide the President or the Executive Secretary with fair opportunity to consider whether the matter indeed calls for a claim of executive privilege. If after the lapse of the reasonable time, neither the President nor the Executive Secretary invokes the privilege, Congress is no longer bound to respect the failure of the official to appear before Congress and may then opt to avail of the necessary legal means to compel his appearance. Privilege is not absolute. Claim of executive privilege is subject to balancing against other interests. In other words, confidentiality in executive privilege is not absolute protected by the Constitution. Neither the doctrine of separation of powers nor the need for confidentiality of high-level communications without more can sustain an absolute unqualified presidential privilege of immunity from judicial process under all circumstances. A claim of executive privilege does not guard against a possible disclosure of a crime or wrongdoing. Neri versus Senate. Type of executive privilege. 1. State secrets regarding military, diplomatic, and other security matters. 2. Identity of government informers. 3. Information related to pending investigation. 4. Presidential communications. 5. Deliberative process. Variety of executive privilege according to tribe. Tribe cited in Senate versus Ermita. 1. State secrets privilege. That the information is of such nature that its disclosure would subvert crucial military or diplomatic objectives. 2. Informers privilege. Privilege of the government not to disclose the identity of persons who furnish information of violations of law to officers charged with the enforcement of that law. 3. General privilege for internal deliberations, said to attach to intra-governmental documents reflecting advisory opinions, recommendations, and deliberations comprising part of a process by which governmental decisions and policies formulated. Two kinds of privilege under in re sealed case, Neri versus Ernita: presidential communication privilege, deliberative process privilege. Presidential communication privilege pertains to communications, documents, or other materials that reflect presidential decision making and deliberations that the president believes should remain confidential. Applies to decision making of the president, rooted in the constitutional principle of separation of powers and the president's unique constitutional role. Applies to documents in their entirety and covers final and post-decisional materials as well as pre-deliberative ones. Deliberative process privilege includes advisory opinions, recommendations, and deliberations comprising part of a process by which governmental decisions and policies are formulated. Applies to decision making of executive officials, rooted on common law privileges. Elements of presidential communications privilege. Neri versus Senate. 1. The protected communication must relate to a quintessential and non-delegable presidential power. Quintessential means representing the most perfect or typical example of a quality or class, synonymous to typical, prototypical, or classic, model, essential. Number 2, the communication must be authored or solicited and received by a close advisor of the president or the president himself. The judicial test is that an advisor must be in operational proximity with the president. Number 3, the presidential communications privilege remains a qualified privilege that may be overcome by a showing of adequate need, such that the information sought likely contains important evidence, and by the unavailability of the information elsewhere by an appropriate investigating authority. 9. Presidential communications are presumptively privileged. The presumption is based on the President's generalized interest in confidentiality. The privilege is necessary to guarantee the candor of presidential advisors and to provide the President and those who assist him with freedom to explore alternatives in the process of shaping policies and making decisions, and to do so in a way many would be unwilling to express except privately. The presumption can be overcome only by mere showing of public need by the branch seeking access to conversation. The courts are enjoined to resolve the competing interests of the political branches of the government in the manner that preserves the essential functions of each branch. 10. Executive privilege in the public. The court held that this jurisdiction recognizes the common law, holding that there is a governmental privilege against public disclosure with respect to state secrets regarding military, diplomatic, and other national security matters and cabinet closed-door meetings. Chavez vs. PCGG. Power to inquiry versus executive privilege. Requirement invoking the privilege. Formal claim of privilege. Congress has undoubtedly has the right to information from the executive branch whenever it is sought in aid of legislation. If the executive branch withholds such information on the ground that it is privileged, it must so assert it and state the reason therefore and why it must be respected. Justice Carpio Morales in Senate versus Ermita. A formal and proper claim of executive privilege requires a specific designation and description of the documents within its scope, as well as precise and certain reasons for preserving their confidentiality. Without this specificity, it is impossible for a court to analyze the claim short of disclosure of the very things sought to be protected. Upon the other hand, Congress must not require the executive to state the reason for the claim with such particularity as to compel disclosure of the information which the privilege is meant to protect. Senate versus Ermita. Neri versus Senate Committee. Background. This case is about the Senate investigation of anomalies concerning the NBN-CTE project. During the hearings, former NEDA head Romulo Neri refused to answer certain questions involving his conversations with President Arroyo on the ground they are covered by executive privilege. When the Senate cited him in contempt and ordered his arrest, Neri filed a case against the Senate with the Supreme Court. On March 25, 2008, the Supreme Court ruled in favor of Neri and upheld the claim of executive privilege. Issue. Are the communications sought to be elicited by the three questions covered by executive privilege? Number 2. Did the Senate committees commit grave abuse of discretion in citing Neri in contempt and ordering his arrest? Ruling. Number 1. The Supreme Court said that the communications sought to be elicited by the three questions are covered by the presidential communications privilege, which is one type of executive privilege. Using the elements of presidential communications privilege, the Supreme Court is convinced that the communications elicited by the three questions are covered by the presidential communications privilege. First, the communications relate to a quintessential and non-delegable power of the president. Example, the power to enter into an executive agreement with other countries. This authority of the president to enter into executive agreements without concurrence of the legislature has traditionally been recognized in Philippine jurisprudence. Second, the communications are received by a close advisor of the president. Under the operational proximity test, petitioner can be considered a close advisor, being a member of President Arroyo's cabinet. Third, there is no adequate showing of a compelling need that would justify the limitation of the privilege and of the unavailability of the information elsewhere by an appropriate investigating authority. The record is bereft of any categorical explanation from respondent committees to show a compelling or critical need for the answer to the three questions in the enactment of law. Answer to number 2. Yes, the Supreme Court said that the Senate committees committed grave abuse of discretion in citing Neri in contempt. The following reasons, among others, was given by the Supreme Court. A. There was a legitimate claim of executive privilege. For the claim to be properly invoked, there must be a formal claim by the President stating the precise and certain reasons for preserving confidentiality. The grounds relied upon by Executive Secretary Ermita are specific enough, since what is required is only that an allegation be made whether the information demanded involves military or diplomatic secrets, closed-door cabinet meetings, etc. The particular ground must only be specified, and the following statement of grounds by Executive Secretary Ermita satisfies the requirement. The context in which executive privilege is being invoked is that the information sought to be disclosed might impair our diplomatic as well as economic relations with the People's Republic of China. Comments on Neri versus Senate. Attorney Medina, the ruling expands the area of information that is not accessible to the public. Executive privilege can now be invoked in communications between his close advisors. Bernas, the problem with the doctrine is anytime the president says that's covered, that's it. Nobody can ask any more questions. ASM, I think when the president says it's covered, the court can still make an inquiry under the grave abuse clause. This inquiry can be done in an executive session. Cabinet. Extra constitutional creation. Although the Constitution mentions the cabinet a number of times, the cabinet itself as an institution is extra constitutionally created. Composition. It is essentially consists of the heads of departments who through usage have formed a body of presidential advisor who meet regularly with the president. Prohibition 1987-1996 bar questions. Applies to member of cabinet, their deputies, or assistants. 1. Unless otherwise provided in the Constitution, shall not hold any other employment during their tenure. 2. Shall not directly or indirectly practice any other profession, participate in any business, or be financially interested in any contract with or in any franchise or special privilege granted by the government or any other subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations of their subsidiaries during their tenure. 3. Strictly avoid conflict of interest in the conduct of their office during their tenure. Section 13. Vice President. Note that the Vice President may be appointed to the Cabinet without need of confirmation by the Commission on Appointments, and the Secretary of Justice is an ex officio member of the Judicial Bar Council. Judicial and Bar Council, ex officio capacity. The prohibition must not be construed as applying to posts occupied by the executive officials without additional compensation in an ex officio capacity as provided by law and as required by the primary functions of said officials office. The reason is that the posts do not comprise any other office within the contemplation of the constitutional prohibition, but properly an imposition of additional duties and functions on said officials. To illustrate, the Secretary of Transportation and Communication is the ex officio chairman of the Board of Philippine Post Authority, the ex officio position being actually and in legal contemplation part of the principal office. It follows that the official concerned has no right to receive additional compensation for his services in said position. The reason is that these services are already paid for and covered by the compensation attached to the principal office. Prohibitive employment. Since the Chief Presidential Legal Counsel has the duty of giving independent and impartial legal advice on the actions of the heads of various executive departments and agencies, and to review investigations involving other presidential appointees, he may not occupy a position in any of the offices whose performance he must review. It would involve occupying incompatible positions. Thus, he cannot be chairman at the same time of the PCGG, since the PCGG answers to the president. Prohibitive compensation. When an undersecretary sits for a secretary in a function from which the secretary may not receive additional compensation, the prohibition of the secretary also applies to the undersecretary. That confused me. When an undersecretary sits for a secretary in a function from which the secretary may not receive additional compensation, the prohibition on the secretary also applies to the undersecretary. Okay, still confused me. The President. The President is the head of state and the chief executive. He is the executive. He is the repository of all executive powers. Section 2. Qualifications. No person may be elected president unless he is a natural-born citizen of the Philippines, a registered voter, able to read and write, at least 40 years of age on the day of the election, and a resident of the Philippines for at least 10 years immediately preceding such election. Reason for qualifications. Qualifications are prescribed for public office to ensure the proper and fair performance of powers and duties. Qualifications are exclusive. The above qualifications are exclusive and may not be reduced or increased by Congress. The applicable rule of interpretation is expression unius est exclusio alterius. Natural born, one who is citizen of the Philippines from birth without having to perform any act to acquire or perfect his Philippine citizenship. Article 4, Section 2. An illegitimate child of an American mother and a Filipino father is a natural born Filipino citizen if paternity is clearly proved. Hence, such person would be qualified to run for president. This was the case of Fernando Po Jr., Texon versus Comelec. Registered voter, possession of the qualifications for suffrage as enumerated in Article 5, Section 1. Age. The age qualification must be possessed on the day of the election for president, that is, on the day set by law on which the votes are cast. Number 7, residence qualification. To object being to ensure close touch by the president with the country of which he is to be highest official and familiarity with its conditions and problems, the better for him to discharge his duties effectively. Section 4. Election. The President and the Vice President shall be elected by direct vote of the people for the term of 6 years, which shall begin at noon on the 30th day of June, next following the day of the election, and shall end at noon of the same date 6 years thereafter. The President shall not be eligible for any re-election. No person who has succeeded as President and has served as such for more than 4 years shall be qualified for re-election to the same office at any time. No Vice President shall serve for more than 2 successive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of the service for the full term for which he was elected, unless otherwise provided by law. The regular election for President and Vice President shall be held on the second Monday of May. The returns of every election for President and Vice President, duly certified by the Board of Canvassers of each province or city, shall be transmitted to the Congress, directed to the President of the Senate. Upon receipt of the certificates of canvass, the President of the Senate shall, not later than 30 days after the day of the election, open all the certificates in the presence of the Senate and the House Representatives in joint public session, and the Congress, upon determination of the authenticity and due execution thereof in the manner provided by law, canvass the votes. The person having the highest number of votes shall be proclaimed elected, but in case 2 or more shall have an equal and highest numbers of votes, one of them shall forthwith be chosen by the vote of a majority of all members of both houses and of Congress voting separately. The Congress shall promulgate its rules for the canvassing of the certificates. The Supreme Court sitting en banc shall be the sole judge of all contests relating to the election, returns, and qualification of the President or Vice President, and may promulgate its rules for the purpose. Regular election. The President and Vice President shall be elected by direct vote of the people, unless otherwise provided by law. The regular election for President and Vice President shall be held on the second Monday of May. Special election. Alright, number 3. Congress as canvassing board. The returns of every election for President and Vice President, duly certified by the Board of Canvassers of each province or city, shall be transmitted to the Congress, directed to the President of the Senate. Upon receipt of the certificate of canvass, the President of the Senate shall, not later than 30 days after the day of the election, open all the certificates in the presence of the Senate and the House Representatives in joint public session, and the Congress, upon determination of the authenticity and due execution thereof in the manner provided by law, canvass the votes. The Congress shall promulgate its rules for the canvassing of the certificate. Is the function of Congress merely ministerial? Bernas. The function of Congress is not merely ministerial. It has authority to examine the certificates of canvass for authenticity and due execution. For this purpose, Congress must pass a law governing their canvassing of votes. Cruz. As the canvass is regarded merely as a ministerial function, the Congress shall not have the power to inquire into or decide questions of alleged irregularities in the conduct of the election contest. Normally, as long as the election returns are duly certified and appear to be authentic, the Congress shall have no duty but to canvass the same and to proclaim as elected the person receiving the highest number of votes. Justice Carpio Morales. This duty has been characterized as being ministerial and executive. Validity of Joint Congressional Committee. Congress may validly delegate the initial determination of the authenticity and due execution of the certificates of canvass to a joint congressional committee so long as the decision and final report of the said committee shall be subject to the approval of the joint session of both houses of Congress voting separately. Lopez versus Senate. COMELEC. There is no constitutional or statutory basis for COMELEC to undertake a separate and unofficial tabulation of result, whether manually or electronically. If COMELEC is proscribed from conducting an official canvass of the votes cast for the President and Vice President, the COMELEC is, with more reason, prohibited from making an unofficial canvass for said votes. Brillantes versus COMELEC. The proclamation of presidential and vice presidential winners is a function of Congress and not of COMELEC. Macalintal versus COMELEC. Congress may continue the canvass even after the final adjournment of its session. The final adjournment of Congress does not terminate an unfinished presidential canvass. Adjournment terminates legislation, but not the non-legislative functions of Congress, such as canvassing of votes. Pimentel versus Joint of Committee of Congress. The person having the highest number of votes shall be proclaimed elected, but in case two or more shall have an equal and highest number of votes, one of them shall forthwith be chosen by the vote of a majority of all the members of both houses of Congress voting separately. Presidential Electoral Tribunal. The Supreme Court sitting in bank shall be the sole judge of all contests relating to the election returns and qualifications of the President or Vice President and may promulgate its rules for the purpose. Can Susan Ross's widow Fernando Poe Jr. intervene and or substitute for him, assuming arguendo that the protest could survive his death? Answer: no. The fundamental rule applicable in a presidential election protest is Rule 14 of the PET rules. It provides that only the second and third placer may contest the election. The rule effectively excludes the widow of a losing candidate, Fernando versus Arroyo. The validity, authenticity, and correctness of the SOVs and COCs are under the tribunal's jurisdiction. The constitutional function as well as the power and the duty to be the sole judge of all contests relating to election, returns, and qualification of President and Vice President is expressly vested in the PET in Section 4, Article 7 of the Constitution. Included therein is a duty to correct manifest errors in the SOVs and COCs, Legarda versus De Castro. Q. After Fidel Ramos was declared president, defeated candidate Miriam Defensor Santiago filed an election protest with the Supreme Court. Subsequently, while the case is pending, she ran for the office of senator and, having been declared elected, assumed office of a senator. What happens to her election protest? Her protest is deemed abandoned with her election and assumption of office as senator. Defensor Santiago versus Ramos. Terms of office 6 years. Noon of June 30. Term shall begin at noon at the 30th day of June next following the day of the election and shall end at the noon of the same date 6 years thereafter. No re-election. The president shall not be eligible for any re-election. No person who has succeeded as president and has served as such for more than 4 years shall be qualified or for election to the same office at any time. Reason for prohibition of any re-election for president. It was thought that the elimination of the prospect of re-election would make for a more independent president capable of making correct, even unpopular decisions. He is expected to devote his attention during his lone term to the proper discharge of his office instead of using his perquisites to ensure his remaining therein for another term. Oath of office. Section 5. Before they enter on the execution of their office, the president, the vice president, or the acting president shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully and conscientiously fulfill my duties as president or vice president or acting president of the Philippines, preserve and defend its constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation, so help me God. In case of affirmation, last sentence will be omitted. Which one? The so help me God? Oath. The oath is not a source of substantive power, but it merely intended to deepen the sense of responsibility of the President and ensure a more conscientious discharge of his office. Privileges. Section 6. The President shall have an office residence. The salaries of the President and Vice President shall be determined by law and shall not be decreased during their tenure. No increase in said compensation shall take effect until after the expiration of the term of the incumbent, during which such increase was approved. They shall not receive during their tenure any other emolument from the government or any other source. Official residence. The President shall have an official residence. Salary. The salaries of the President and Vice President shall be determined by law and shall not be decreased during their tenure. The initial salary of the President is 300,000 per year. Article 18, Section 17. No increase during their term. No increase in said compensation shall take effect until after the expiration of the term of the incumbent, during which such increase was approved. No additional emolument during their tenure. They shall not receive during their tenure any other emolument from the government or any other source. Immunity from suit will be discussed under Section 1. Prohibitions or Inhibitions. Section 13. The President, Vice President, the members of the Cabinet, and their deputies or assistants shall not, unless otherwise provided in this Constitution, hold any other office or employment during their tenure. They shall not, during said tenure, directly or indirectly practice any other profession, participate in any business, or be financially interested in any contract with, or in any franchise or special privilege granted by the government, or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations of their subsidiaries. They shall strictly avoid conflict of interest in the conduct of their office. The spouse and relatives by consanguinity or affinity within the fourth civil degree of the President shall not, during his tenure, be appointed as members of the constitutional commissions, or the office of the Ombudsman, or as secretaries, undersecretaries, chairman, or heads of bureaus or head office, including government-owned or controlled corporation and their subsidiaries. Relatives by sanguinity or affinity within the fourth civil degree. Vacancy. Section 7. The President-elect, the Vice President-elect shall assume office at the beginning of their terms. If the President-elect fails to qualify, the Vice President-elect shall act as President until the President-elect shall have qualified. If a President shall not have been chosen, the Vice President-elect shall act as President until a President shall have been chosen and qualified. If at the beginning of the term of the President-elect shall have died or shall have become permanently disabled, the Vice President-elect shall become President. Where no President and Vice President shall have been chosen or shall have qualified, or where both shall have died or become permanently disabled, the President of the Senate, or in case of his inability, the Speaker of the House of Representatives shall act as President until a President or a Vice President shall have been chosen and qualified. The Congress shall, by law, provide for the manner in which one who is to act as President shall be selected until a President or a Vice President shall have qualified. In case of death, permanent disability, or inability of the official mentioned in the next preceding paragraph. Section 8. In case of death, permanent disability, removal from office, or resignation of the President, the Vice President shall become the President to serve the unexpired term. In case of death, permanent disability, removal from office, or resignation of both the President and Vice President, the President of the Senate, or in case of his inability, the Speaker of the House of Representatives shall then act as President until the President or Vice President shall have been elected and qualified. The Congress shall, by law, provide who shall serve as President in case of death, permanent disability, or resignation of the acting President. He shall serve until the President or the Vice President shall have been elected and qualified, and be subject to the same restrictions of powers and qualifications as the acting President. Section 10. The Congress shall, at 10 o'clock in the morning of the third day after the vacancy in the offices of the President and Vice President occurs, convene in accordance with its rules without need of a call, and within 7 days enact a law calling for a special election to elect a president and a vice president to be held not earlier than 45 days, nor later than 60 days from the time of such call. The bill calling such a special election shall be deemed certified under paragraph 2, section 26, Article 6 of this Constitution, and shall become law upon its approval on third reading by the Congress. Appropriations for the special election shall be charged against any current appropriations and shall be exempt from the requirements of paragraph 4, section 25, Article 6 of this Constitution. The convening of the Congress cannot be suspended, nor the special election postponed. No special election shall be called if the vacancy occurs within 18 months before the date of the next presidential election. Before 18 months before the date of the next presidential election. Vacancy situations. Vacancy that occurs at the start of the term, Section 7. Vacancy that occurs in the midterm, Section 8. Vacancy in both the president and vice president, Section 10. Vacancy situations under Section 7. The vacancy situations here occur after the office has been initially filled. 1. When the president has been chosen but fails to qualify at the beginning of his term. 2. When no president has yet been chosen at the time he is supposed to assume office. 3. When the president-elect dies or is permanently incapacitated before the beginning of his term. 4. When both the president and vice president have not yet been chosen or have failed to qualify. 5. When both shall have died or become permanently incapacitated at the start of the term. 6. When the Senate President and the Speaker of the House shall have died or shall have become permanently incapacitated or are unable to assume office. Vacancy situation under Section 8. 1. When the incumbent president dies or is permanently disabled or removed or resigned. 2. When both the president and the vice president die or are permanently disabled, are removed or resigned. 3. When the acting president dies or is permanently incapacitated or removed or resigns. Rules of succession. Section 7. When the president has been chosen but fails to qualify for the beginning of this term, or when no president has yet been chosen at the time he is supposed to assume office, the vice president becomes acting president until a president qualifies. 3. When the president-elect dies or is permanently incapacitated before the beginning of its term, vice president-elect becomes president. When both the president and the vice president have not yet been chosen or have failed to qualify, or when both shall have died or become permanently incapacitated at the start of the term, the Senate President or the Speaker in that order acts as president until a president or vice president qualifies. When the Senate President and the Speaker of the House shall have died or shall have become permanently incapacitated or are unable to assume office, Congress will decide by law who will act as president until a president or vice president shall have been elected and qualified. Reason for vacancy. When the incumbent president dies or is permanently disabled or removed or resigns. Succession. The vacancy created is thus permanent and the vice president becomes president. When both the president and vice president die or are permanently disabled, are removed or resigned, the Senate President of the Speaker, in that order, shall act as president until a president or vice president shall have been qualified. When the acting president dies or is permanently incapacitated, is removed or resigned, Congress will determine by law who will act as president until a new president or vice president shall have qualified. Resignation. In Estrada versus Macapagal-Arroyo, the Supreme Court, through Justice Puno, main opinion, declared that the resignation of President Estrada could not be doubted as confirmed by his leaving Malacanang. The Supreme Court declared that the elements of a valid resignation are intent to resign, 2. Act of relinquishment. Both were present when President Estrada left the palace. Justice Puno anchored his opinion mainly on the letter of Estrada and on the diary of E.S. Eduardo Angara. Permanent disability. In Estrada versus Macapagal-Arroyo, Justice Bello Silo anchored his concurrence on permanent disability. He opined that permanent disability as contemplated by the Constitution does not refer only to physical or mental incapacity, but must likewise cover other forms of incapacities of a permanent nature, example, functional disability. He views Estrada's disability in A. Objective and B. Subjective perspective, objective approach, without people, an objectively functional cabinet, the military and the police, with no recognition from Congress and the International Committee. Estrada had absolutely no support from and control of the bureaucracy from which and from without. In fact, he had no more functioning government to speak of. It is in this context that Estrada was deemed absolutely unable to exercise or discharge the powers, duties, and prerogatives of the presidency. Functional disability. Subjective approach. Estrada's contemporaneous acts and statements during and after the critical episodes are eloquent proof of his implied but nevertheless unequivocal acknowledgement of the permanence of his disability. Comment on Estrada versus Macapagal Arroyo from Bernas. In sum, 3 justices, Puno, Vitug, and Pardo, accepted some form of resignation. 2 justices, Mendoza and Belosilo, saw permanent disability. 3 justices, Capuno, Inares Santiago, and Sandoval Gutierrez, accepted presidency of Arroyo as an irreversible fact. 5 justices, Quisumbing, Melo, Buena, De Leon, and Gonzaga Reyes, signed the decision without expressing an opinion. Davide and Pangaliban abstained. In the light of all this, it is not clear what doctrine was established by the decision. When the Senate President or Speaker becomes acting President, he does not lose the Senate Presidency or the Speakership. Section 10. Call not needed. The Congress shall at 10 o'clock in the morning of the 3rd day after the vacancy in the office of the President and Vice President occurs, convene in accordance with its rules without need of a call, and within 7 days enact a law calling for a special election to elect a President and a Vice President to be held not earlier than 45 days nor later than 60 days from the time of such call. Bill deemed certified. The bill calling such special election shall be deemed certified under paragraph 2, section 26, article 6 of this Constitution, and shall become law upon its approval on 3rd reading by the Congress. Appropriations. Appropriations for the special election shall be charged against any current appropriations and shall be exempt from the requirements of paragraph 4, section 25, article 6 of the Constitution. No suspension or postponement. The convening of the Congress cannot be suspended, nor the special election postponed. No special election. No special elections shall be called if the vacancy occurs within 18 months before the date of the next presidential election. Temporary disability. Section 11. Whenever the President transmits to the President of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration of the contrary, such powers and duties shall be discharged by the Vice President as acting President. Whenever a majority of all the members of the Cabinet transmit to the President of the Senate and to the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President of the Senate and to the Speaker of the House of Representatives his written declaration that no inability exists, he shall reassume the powers and duties of his office. Meanwhile, should a majority of all the members of the Cabinet transmit within 5 days to the President of the Senate and to the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Congress shall decide the issue. For that purpose, the Congress shall convene, if it is not in session, within 48 hours, in accordance with its rules and without need of call. If the Congress within 10 days after receipt of the last written declaration, or if not in session, within 12 days after it is required to assemble, determines by a 2/3 vote of both houses, voting separately, that the President is unable to discharge the powers and duties of his office, the Vice President shall act as President. Otherwise, the President shall continue exercising the powers and duties of his office. Serious illness. Section 12. In case of serious illness of the President, the public shall be informed of the state of his health. The members of the cabinet in charge of national security and foreign relations and the Chief of Staff of the Armed Forces of the Philippines shall not be denied access to the President during such illness. Section 12 envisions not just illness which incapacitates but also any serious illness which can be a matter of national concern. Reason for informing the public: to guarantee the people's right to know about the state of the President's health, contrary to secretive practice in totalitarian regimes. Who has a duty to inform? The section does not specify the officer on whom the duty devolves. It is understood that the office of the President would be responsible for making the disclosure. Reason of the access: to allow the President to make the important decisions in those areas of government. Removal from office: ways of removal from office: by impeachment, by people power, by killing the President. Example, assassination. Number 2 is extra constitutional and number 3 is illegal. But for purposes of examination, answer number 1 only. Impeachment will be discussed under Article 11. Okay. Ways of removal from office. It says here in the notes, but for purposes of examination, answer number 1 only, by impeachment, because number 2 is extra constitutional and number 3 is illegal. Who is the Vice President? His function is to be on hand, to act as President when needed, or to succeed to the presidency in case of a permanent vacancy in the office. The President may also appoint him as a member of the Cabinet. Such appointment does not need the consent of the Commission on Appointments. Qualification: election term 6 years. There shall be a President who shall have the same qualifications and term of office to be elected with in the same manner as the President. No Vice President shall serve for more than 2 successive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of the service for the full term for which he was elected. Oath of office: same as the President. Prohibition and inhibition: shall not receive increased compensation during the term of the incumbent during which such increase was approved. Number 2, shall not receive any other emoluments from the government or any other source during their tenure. 3, unless otherwise provided in the Constitution, shall not hold any other employment during their tenure. 4, shall not directly or indirectly practice any other profession, participate in any business, or be financially interested in any contract with, or in any franchise or special privilege granted by the government or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporation, of their subsidiaries during their tenure. Strictly avoid conflict of interest in the conduct of their office during their tenure. Vacancy in the Vice President. Section 9. Whenever there is a vacancy in the office of the Vice President during the term for which he was elected, the President shall nominate a Vice President from among the members of the Senate and the House of Representatives, who shall assume office upon confirmation by a majority vote of all the members of both houses of the Congress, voting separately. Removal from office. He may be removed from office in the same manner as President. Appointment to Cabinet. The Vice President may be appointed as a member of the Cabinet. Such appointment requires no confirmation. Justice Cruz submits that the Vice President may not receive additional compensation as member of Cabinet because of the absolute prohibition in Section 3, Article 7. Powers of the President. Constitutional powers of the President. 1. Executive power, power of appointment, power of control, military power, pardoning power, borrowing power, diplomatic power, budgetary power, informing power, other powers. Call Congress to a special session, power to approve or veto bills, to consent to deputation of government personnel but commission on election, to discipline such deputies, emergency powers by delegation from Congress, tariff power by delegation from Congress, general supervisions over local governments and autonomous regional governments. Power of appointment. Section 16. The President shall nominate, and with the consent of the Commission on Appointments, appoint the heads of the executive departments, ambassadors, other public ministers and consuls, or officers of the armed forces from the rank of colonel or naval captain, and other officers whose appointments are vested in him in this Constitution. He shall also appoint all other officers of the government whose appointments are not otherwise provided for by law, and those whom he may be authorized by law to appoint. The Congress may, by law, vest the appointment of other officer lower in rank in the President alone, in the courts, or in the heads of department, agencies, commissions, or boards. The President shall have the power to make appointments during the recess of the Congress, whether voluntary or compulsory, but such appointments shall be effective only until disapproval by the Commission on Appointments or until the next adjournment of the Congress. Definition of appointment. Appointment is the selection by the authority vested with the power of an individual who is to exercise the functions of a given office. It is distinguished from designation in that the latter simply means the imposition of additional duties, usually by law, on a person already in the public service. It is also different from the commission in that the latter is the written evidence of the appointment. Executive in nature. Nature of power of appointment. Executive in nature. Appointing of power is executive in nature. Government versus Springer. Indeed, the filing up of an office created by law is the implementation or execution of law. Although intrinsically executive and therefore pertaining mainly to the President, the appointing power may be exercised by the legislature and by the judiciary as well as the constitutional commissions over their own respective personnel. Implication. Since appointment to office is an executive function, the clear implication is that the legislature may not usurp such function. The legislature may create an office and prescribe the qualifications of the person who may hold the office, but it may neither specify who shall be appointed to such office nor actually appoint him. Non-delegability. Facts. The Minister of Tourism designate petitioner as general manager of the Philippine Tourism Authority. When a new Secretary of Tourism was appointed, the President designated him as the general manager of the PTA on the ground that the designation of petitioner was invalid since it is not made by the President, as provided for in PD 564. Petitioner claimed that his removal was without just cause. Hell, the appointment of or designation of petitioner by the Minister of Tourism is invalid. It involves the exercise of discretion, which cannot be delegated. Even if it be assumed that the power could be exercised by the Minister of Tourism, it could be recalled by the President, for the designation was provisional. Binamira versus Garucho. Necessity of discretion. Discretion is an indispensable part in the exercise of power of appointment. Congress may not, therefore, enact a statute which would deprive the President of the full use of his discretion in the nomination and appointment of persons to any public office. Thus, it has been held that a statute unlawfully limits executive discretion in appointments when it provides for the drawing of lots as a means to determine the districts to which judges of first instance should be assigned by the chief executive. Congress may not limit the President's choice to one because it will encroachment on the prerogative of the President. Appointment is essentially a discretionary power and must be performed by the officer in which it is vested according to his best lights, the only condition being that the appointee, if issued a permanent appointment, should possess the minimum qualification requirements, including the civil service eligibility prescribed by law for the position. This discretion also includes the determination of the nature or character of the appointments, example, whether the appointment is temporary or permanent. The power to appoint includes the power to decide who among various choices is best qualified, provided that the person chosen has the qualification provided by law. Even the next in rank rule of the Civil Service Code cannot be read as binding the appointing authority to choose the first in the order of rank when two or more possesses the requisite qualifications. Q. The Revised Administrative Code of 1987 provides all provincial and city prosecutors and their assistants shall be appointed by the President upon the recommendation of the Secretary. Is the absence of recommendation of the Secretary of Justice to the President fatal to the appointment of a prosecutor? Answer. Appointment calls for discretion on the part of the appointing authority. The power to appoint prosecutors is given to the President. The Secretary of Justice is under the control of the President. Hence, the law must be read simply as allowing the Secretary of Justice to advise the President. Bermudez versus Secretary. Classification of appointment. Permanent. Permanent appointments are those extended to persons possessing eligibility and are thus protected by the constitutional guarantee of security of tenure. Temporary appointments are given to persons without such eligibility, revocable at will and without the necessity of just cause or valid investigation, made on the understanding that the appointing power has not yet decided on the permanent appointee and that the temporary appointee may be replaced at any time a permanent choice is made. Not subject to CA confirmation. The temporary appointment and a designation are not subject to confirmation by the Commission on Appointments. Such a confirmation, if given erroneously, will not make the incumbent a permanent appointee. Valencia versus Peralta. Regular. A regular appointment is one made by the President while Congress is in session, takes effect only after confirmation by the Commission on Appointments, and once approved, continues until the end of the term of the appointee. Ad interim. An ad interim appointment is one made by the President while Congress is not in session, takes effect immediately but ceases to be valid if disapproved by the Commission on Appointments, or upon the next adjournment of Congress. In the latter case, the ad interim appointment is deemed bypassed through inaction. The ad interim appointment is intended to prevent interruptions in vital government services that would otherwise result from prolonged vacancies in government offices. Ad interim appointment is a permanent appointment. It is a permanent appointment because it takes effect immediately and can no longer be withdrawn by the President once the appointee qualified into office. The fact that it is subject to confirmation by the Commission on Appointments does not alter its permanent character. Matibag versus Benipayo. Ad interim appointment, how terminated. Disapproval of the appointment of the Commission on Appointments. 2. Adjournment by Congress without the CA acting on the appointment. There is no dispute that when the Commission on Appointments disapprove an ad interim appointment, the appointee can no longer be extended a new appointment, inasmuch as the approval is a final decision of the Commission in the exercise of its checking power on the appointing authority of the President. Such disapproval is final and binding on both the appointee and appointing power. But when an ad interim appointment is bypassed because of lack of time or failure of the Commission on Appointments to organize, there is no final decision by the Commission to give or withhold its consent to the appointment. Absent such decision, the President is free to renew the ad interim appointment. Matibag versus Benipayo. Question: what happens if a special session is called and that session continues until the day before the start of the regular session? Do appointments given prior to the start of the special session lapse upon the end of the special session, or may they continue into regular sessions? Answer: Guevara versus Inocente again says that there must be a constructive recess between the sessions, and thus appointments not acted upon during the special session lapse before the start of the regular session. Difference between an ad interim appointment and an appointment in acting capacity. The former refers only to positions which need confirmation by the CA, while the latter is also given to those which do not need confirmation. The former may be given only when Congress is in session, whereas the latter may be given when Congress is in session. Acting capacity. The essence of an appointment in an acting capacity is its temporary nature. In case of a vacancy of an office occupied by an alter ego of the President, such as the office of Department Secretary, the President must necessarily appoint the alter ego of her choice as acting secretary before the permanent appointee of her choice could assume office. Congress, through law, cannot impose on the President the obligation to appoint automatically the Undersecretary as her temporary alter ego. An alter ego, whether temporary or permanent, holds a position of great trust and confidence. Congress, in the guise of prescribing qualifications to an office, cannot impose on the President who her alter ego should be. Acting appointments are a way of temporarily filling the important offices, but if abused, they can also be a way of circumventing the need of for confirmation by the Commission on Appointments. However, we find no abuse in the present case. The absence of abuse is apparent from President Arroyo's issuance of an ad interim appointment to respondents immediately upon the recess of Congress, way before the lapse of 1 year. Pimentel versus Ermita. Kinds of presidential appointment. Appointment made by an acting president. Number 2. Appointment made by the President with 2 months before the next presidential elections and up to the end of his term. Number 3, regular appointments. Number 4, recess or ad interim appointments. Scope of the power to appoint. Officials to be appointed by the President. Those officials whose appointments are vested in him by the Constitution, Section 16, Paragraph 1. Heads of executive departments, ambassadors, other public ministers and consuls, officers of the armed forces from rank of colonel or naval captain. Article 8. Section 9 provides that the President appoints member of the Supreme Court and judges of lower courts. The President also appoints member of JBC, chairman and members of the Constitutional Commission. Articles 9b, Section 1, 2, C, Section 1, 2. The Ombudsman and his deputies, Article 11, Section 9. Appointment of sectorial representatives, Article 18, Section 7. Quintos Teles versus Commission on Appointments. Number 2. Those whom he may be authorized by law, Section 16, second sentence. Any other officers of the government whose appointments are not otherwise provided by law, Constitution, or statutes, Section 16, second sentence. Significance of enumeration in Section 16, the first sentence. The enumeration means that the Congress may not give to any other officer the power to appoint the above enumerated officers. Appointments needing the confirmation of CA, or the Commission on Appointment. 1. What appointments need confirmation by the Commission on Appointments? Those enumerated in the first sentence of Section 16. 1. Heads of executive departments. 2. Ambassadors, other public ministers and consuls. 3. Officers of the armed forces from rank of colonel or naval captain. 4. Those other officers whose appointments are vested in him in the Constitution, Sarmiento versus Mison. Note, although the power to appoint justices, judges, ombudsman, and his deputies is vested in the President, such appointments do not need confirmation by the Commission on Appointments. Although the power to appoint justices, judges, ombudsman, and his deputies is vested in the President, such appointments do not need confirmation by the Commission on Appointments. Why from rank of colonel? The provision hopefully will have the effect of strengthening civilian supremacy over the military to some extent. The decision of the Commission was influenced by the observation that coups are generally led by colonels. Military officers. The clause officers of the armed forces from the rank of colonel or naval captain refers to the military officers alone. Hence, promotion and appointment of officers of Philippine Coast Guards, which is under the DOTC and not under the AFP, do not need a confirmation of Commission on Appointments. Soriano versus Lista. Also, promotion of senior officers of the PNP is not subject to confirmation of CA. PNP are not members of the AFP. Manalo versus Zistosa. Chairman of CHR. The appointment of the Chairman of the Commission on Human Rights is not provided for in the Constitution or in the law. Thus, there is no necessity for such appointment to be passed upon by the Commission on Appointments. Bautista versus Salonga. Exclusive list. The Congress cannot, by law, require the confirmation of appointments of government officials other than those enumerated in the first sentence of Section 16, Article 7. Calderon versus Carale. Steps in appointing process where COA confirmation is needed. Nomination by the President. Confirmation of the Commission on Appointments. Issuance of the Commission. Acceptance. An appointment is deemed complete only upon its acceptance. Pending such acceptance, the appointment may still be withdrawn. Lacson versus Romero. Appointment to a public office cannot be forced upon any citizen except for purposes of defense of the state under Article 2, Section 4. Appointment of officers lower in rank. Section 16. Third sentence of the first paragraph. The Congress may, by law, vest the appointment of other officers lower in rank in the President alone, in the courts, or in the heads of departments, agencies, commissions, or boards. Significance of the phrase, the President alone. Alone means to the exclusion of the courts, the heads of departments, agencies, commissions, or board. Appointing authority may also be given to the other officials. Thus, Section 16 says, the Congress may, by law, vest the appointment of other officers lower in rank in the President alone, in the courts, or in the heads of departments, agencies, commissions, or boards. In Rufino versus Endriga interpreted this to mean that when the authority is given to collegial bodies, it is to the chairman that the authority is given. but he can appoint only officers lower in rank and not officers equal in rank to him. Thus, the chairman may not appoint a fellow member of a board. Limitation on the president's appointing power. Section 14. Appointments extended by an acting president shall remain effective unless revoked by the elected president within 90 days from his assumption or reassumption of office. Section 15. 2 months immediately before the next presidential elections and up to the end of his term, a president or acting president shall not make appointments, except temporary appointments to executive positions when continued vacancies therein will prejudice public service or endanger public safety. Special limitations. Anti-nepotism provision. The president may not appoint his spouse and relatives by consanguinity or affinity within the fourth civil degree as members of the Constitutional Commission, as ombudsman or as secretaries, undersecretaries, chairmen or heads of bureaus or offices, including government-owned or controlled corporation. Section 13. 2. Appointments extended by an acting president shall remain effective unless revoked by the elected president within 90 days from his assumption of office. Section 14. 3. Midnight appointments. 2 months immediately before the next presidential elections and up to the end of his term, a president or acting president shall not make appointments except for temporary appointments to executive position when continued vacancy therein will prejudice public service or endanger public safety. Section 15. Fourth, the president shall have the power to make appointments during the recess of the Congress, whether voluntary or compulsory, but such appointments shall be effective only until disapproved by the Commission on Appointments or until the next adjournment of Congress. Section 16, paragraph 2. Provision applies only to presidential appointments. The provision applies only to presidential appointments. There is no law that prohibits local executive officials from making appointments during the last days of their tenure. Provisions apply only to presidential appointments. The provision applies only to presidential appointments. There is no law that prohibits local executive officials from making appointments during the last days of their tenure. Derama versus CA. Old Doctrine, Section 15, applies to the appointments in the judiciary 2 months immediately before the next presidential elections and up to the end of his tenure. A president or acting president shall not make appointments, except temporary appointments, to executive positions when continued vacancies therein will prejudice public service or endanger public safety. Since the exception applies only to executive position, the provision covers appointments to the judiciary. During this period, 2 months immediately before the next presidential election, the president is neither required to make appointments to the courts nor allowed to do so. Section 4, number 1 and 9 of Article 8 simply mean that the president is required by law to fill up vacancies in courts within the same time frames provided there is therein unless prohibited by Section 15 of Article 7. While the filing up of vacancies in the judiciary is undoubtedly in the public interest, there is no showing in this case of any compelling reason to justify the making of the appointments during the period of the ban. In reappointment of Mateo Valenzuela. New Doctrine. The prohibition under Article 7, Section 15 of the Constitution against presidential appointments immediately before the next presidential elections and up to the end of the term of the president does not apply to vacancies in the Supreme Court. Does not apply to the vacancies in the Supreme Court. Other limitations. The presidential power of appointment may also be limited by Congress through its power to prescribe qualifications for public office. 2. The judiciary may annul an appointment made by the president if the appointee is not qualified or has not been validly confirmed. Power of removal. The president possesses the power of removal by implication from other powers expressly vested in him. 1. It is implied from his power to appoint. 2. Being executive in nature, it is implied from the constitutional provision vesting the executive power in the president. 3. It may be implied from his function to take care that laws be properly executed, for without it, his orders for law enforcement might not be effectively carried out. 4. The power may be implied from the president's control over the administrative departments, bureaus, and offices of the government. Without the power to remove, it would not be always possible for the president to exercise his power of control. As a general rule, The power of removal may be implied from the power of appointment. However, the President cannot remove officials appointed by him where the Constitution prescribes certain methods for separation of such officers from public service. Example, chairmen and commissioners of constitutional commissions who can be removed only by impeachment, or judges who are subject to the disciplinary authority of the Supreme Court. In the cases where the power of removal is lodged in the President, the same may be exercised only for cause as may be provided by law, and in accordance with the prescribed administrative procedure. Member of the Career Service. Members of the Career Service of the Civil Service who are appointed by the President may be directly disciplined by him, Villaluz versus Saldivar, provided that the same is for cause and in accordance with the procedure prescribed by law. Members of the Cabinet. Members of the Cabinet and such officers whose continuity in office depends upon the President may be replaced at any time. Legally speaking, their separation is effected not by removal but by expiration of term. Alahar versus CA. Section 17. Power of Control. The President shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed. Control. Control is the power of an officer to alter or modify or nullify or set aside what a subordinate officer had done in the performance of his duties and to substitute the judgment of the former for that of the latter. It includes the authority to order the doing of an act by a subordinate or to undo such act or to assume a power directly vested in him by law. The power of control necessarily includes the power of supervision. Control versus supervision. Control is stronger power than mere supervision. Supervision means overseeing or the power of or authority of an officer to see that subordinate officers perform their duties. If the latter fail or neglect to fulfill them, then the former may take action or steps as prescribed by law to make them perform these duties. Burnous Premier. Power of supervision is the power of the superior officer to ensure that the laws are faithfully executed by inferiors. The power of supervision does not include the power of control, but the power of control necessarily includes the power of supervision. Okay. Control. An officer in control lays down the rules in the doing of an act. If rules are not followed, he may, in his discretion, order the act done, redone, or his subordinate, or he may decide to do it himself. Supervision. Supervision does not cover the authority to lay down the rules. Superior or superintendent merely sees to it that the rules are followed. If the rules are not observed, he may order the work done or redone, but only to conform to the prescribed rules. He may not prescribe his own manner for the doing or the act. He has no judgment on this matter, except to see to it that the rules are followed. Drilon versus Lim. The President and the power of control. The power of control of the President has been given to the President over all executive officers, from cabinet members to the lowliest clerk. This is an element of the presidential system where the President is the executive of the government. The power of control vested in the President by the Constitution makes for a strongly centralized administrative system. It reinforces further his position as the executive of the government, enabling him to comply more effectively with his constitutional duty to enforce laws. The power to prepare the budget of the government strengthens the presidential position as an administrative head. Scope. The President shall have control of all the executive departments, bureaus, and offices. B. The President has control over offices of GOCCs. The Marco versus Arca. Bernas. It is submitted that such power over government-owned corporation comes not from the Constitution, but from statute. Hence, it may also be taken away by statute. Control over what? The power of control is exercisable by the President over the acts of his subordinates and not necessarily over the subordinate himself. Angco versus Castillo. It can be said that while the executive has control over the judgment or discretion of his subordinates, it is the legislature which has control over their person. Theoretically, the President has full control of all the members of the cabinet. He may appoint them as he sees it fit, shuffle them at pleasure, and replace them in his discretion without any legal inhibition whatever. The President may exercise powers conferred by law upon cabinet members or other subordinate executive officers, City of Iligan versus Director of Land. Even where the law provides that the decision of the Director of Lands on questions of fact shall be conclusive when affirmed by the Secretary of DNR, the same may, on appeal to the President, be reviewed and reversed by the Executive Secretary. Lacson Magallanes versus Pano. If it has been held, moreover, that the express grant of the power of control to the President justifies an executive action to carry out the reorganization of an executive office under a broad authority of law, a reorganization can involve the reduction of personnel, consolidation of offices, or even abolition of position by reason of economy or redundancy of functions. While the power to abolish an office is generally lodged with the legislature, the authority of the President to reorganize the executive branch which may include such abolition, is permissible under present laws. Banda versus Ermita. Facts. President GMA issued Executive Order No. 378 on 2004, amending Section 6 of Executive Order 285 by inter alia, removing the executive jurisdiction of the NPO or National Printing Office over the printing services requirement of government agencies and instrumentalities. Pursuant to Executive Order No. 378, government agencies and instrumentalities are allowed to source their printing services from the private sector through competitive bidding, subject to the condition that the services offered by the private supplier be of superior quality and lower in cost compared to what was offered by the NPO. Executive Order No. 378 also limited NPO's appropriation in the General Appropriations Act to its income. Perceiving Executive Order 378 as a threat to their security of tenure as employees to the NPO, petitioner challenged its constitutionality, contending that, number 1, it is beyond the executive powers of the President Arroyo to amend or repeal Executive Order No. 285, issued by former President Aquino, when the latter still exercised legislative powers, and 2, Executive Order No. 378 violates petitioner's security of tenure because it paves the way for the gradual abolition of the NPO. Issue whether EO 378 is constitutional. Held, yes. Leonardo de Castro. It is a well-settled principle in jurisprudence that the President has the power to reorganize the offices and agencies in the executive department in line with the President's constitutional granted power of control over executive offices and by virtue of previous delegation of the legislative power to reorganize executive offices under existing statutes. Executive Order 292 of the Administrative Code 1987 gives the President continuing authority to reorganize and redefine the functions of the Office of the President. Section 31, Chapter 10, Title 3, Book 3 of the said code is explicit. The President, subject to the policy in the executive office, and in order to achieve simplicity, economy, and efficiency, shall have continuing authority to reorganize and the administrative structure of the Office of the President. It is undisputed that NPO, as an agency that is part of the Office of the Press Secretary, which in various times has been an agency directly attached to the Office of the President Secretary, or as an agency under the Philippine Information Agency, is part of the Office of the President. To be very clear, this delegated legislative power to reorganize pertains only to the Office of the President and the departments, offices, and agencies of the executive branch and does not include the judiciary, the legislature, or the constitutionally created or mandated bodies. Moreover, it must be stressed that the exercise by the President of the power to reorganize the executive department must be in accordance with the Constitution, relevant laws, and prevailing jurisprudence. J. Carpio, RA 9184 mandates the conduct of competitive bidding in all the procurement activities of the government, including the acquisition of items, supplies, materials, and general support services, which may be needed in the transaction of the public businesses or in the pursuit of any government, save for limited transaction, by opening government's procurement of standard and accountable forms to competitive bidding, except for documents crucial to the conduct of clean elections, which has to be printed solely by government. EO 378 merely implements RA 9184's principle of promoting competitiveness by extending equal opportunity to enable private contracting parties who are eligible and qualified to participate in public bidding. Biraugo, PTC. President Noynoy Aquino on July 30, 2010 signed Executive Order No. 1 establishing the Philippine Truth Commission of 2010 Truth Commission. The said truth is dedicated solely to investigating and finding out the truth concerning the reported case of graft and corruption during the previous administration. The respondents through OSG cites the recent case of Banda versus Ermita, where it held that the President has the power to reorganize the offices and agencies in the executive department in line with his constitutionally granted power of control and by virtue of a valid delegation of the legislative power to reorganize executive offices under existing status. According to the OSG, the power to create a truth commission pursuant to the above provision finds statutory basis under PD 1416 as amended by PD 1772. The said law granted the President the continuing authority to reorganize the national government, including the power to group, consolidate bureaus and agencies, to abolish offices, to transfer functions, to create and classify functions, services and activities, transfer appropriations, and to standardize salaries and materials. Issue. Does the creation of the Philippine Truth Commission fall within the ambit of the power to reorganize and as expressed in Section 31 of the Revised Administrative Code held by J. Mendoza? No. Section 31 contemplates reorganization. To say that the Truth Commission is born out of a restructuring of the office of the President under Section 31 is a misplaced supposition, even in the plainest meaning attributable to the term restructure, an alteration of an existing structure. Evidently, the Truth Commission was not part of the structure of the office of the President prior to the enactment of Executive Order No. 1. Reorganization involves the reduction of personnel, consolidation of offices, or abolition thereof by reason of economy or redundancy of functions. It takes place when there is an alteration of an existing structure of government offices or units therein, including the lines of control, authority, and responsibility between them. Issue. Is there a valid delegation of power from Congress to PD 1416 empowering the President to create a public office? Held. No. PD 1416 is already stale, anachronistic, and inoperable. PD 1416 was a delegation to then President Marcos of the authority to reorganize the administrature of the national government, including the power to create offices and transfer appropriations pursuant to one of the purposes of the decree, embodied in its last whereas clause. Whereas, the transition towards the parliamentary form of government will necessitate flexibility in the organization of the national government. Clearly, as it was only for the purpose of providing manageability and resiliency during the interim, PD No. 1416, as amended by PD 1772, became functius officio upon the convening of the First Congress as expressly provided in Section 6, Article 18 of the 1987 Constitution. Note, while it was reorganized in this case of Biraugo versus PTC that the power to conduct investigation is inherent in the power to faithfully execute laws, EO1 by President Noynoy Aquino creating the Truth Commission is held unconstitutional for being violative of the Equal Protection Clause of the Constitution. Okay. Section 17 is a self-executing provision. The President derives power of control directly from the Constitution and not from any implementing legislation. Such a law is in fact unnecessary and will even be invalid if it limits the exercise of his power or withdraws it altogether from the President. Power of control is not the source of the executive disciplinary power. The power of control is not the source of the executive disciplinary power over the person of his subordinates. Rather, his disciplinary power flows from his power to appoint. Ancoco versus Castillo. Alter ego principle, doctrine of qualified political agency. Doctrine. The doctrine recognizes the establishment of a single executive. The doctrine postulates that all executive and administrative organizations are adjuncts of the executive department. The heads of the various executive departments are assistants and agents of the chief executive, and, except in case where the chief executive is required by the Constitution or law to act in person or in exigencies of the situation demand that he act personally, the multifarious executive and administrative functions of the chief executive are performed by and through the executive departments, and the acts of the secretaries of such departments performed and promulgated in the regular course of business are, unless disapproved or reprobated by the chief executive, presumptively the acts of the chief executive. Villena versus Secretary of Interior. Put simply, when a department secretary makes a decision in the course of performing his or her official duties, the decision, whether honorable or disgraceful, is presumptively the decision of the President unless he quickly and clearly disowns it. When doctrine not applicable. Qualified political agency does not apply if the President is required to act in person by law or by the Constitution. Example, the power to grant pardons must be exercised personally by the President. Reason for the doctrine. Since the executive is a busy man, he is not expected to exercise the totality of his power of control all the time. He is not expected to exercise all his powers in person. He is expected to delegate some of them to men of his confidence, particularly to members of his cabinet. Thus, out of his practical necessity has risen what has come to be referred to as doctrine of qualified political agency. Power of control exercised by the department heads in the president's behalf. The president's power of control means his power to reverse the judgment of an inferior officer. It may also be exercised in his behalf by the department's head. Thus, the Secretary of Justice may reverse the judgment of a prosecutor and direct him to withdraw an information already filed. Such action is not directly reviewable by a court. One who disagrees, however, may should appeal to the office of the President in order to exhaust administrative remedies prior to bringing it to court. Power of control exercised by the ES, Executive Secretary. The Executive Secretary, when acting by authority of the President, may reverse the decision of another department secretary. Lacson Magallanes versus Pano. Abacada case. Petitioners argue that the EVAT law is unconstitutional as it constitutes abandonment by Congress of its exclusive authority to fix the rate of taxes and nullify the President's power of control by mandating the fixing of the tax rate by the President upon the recommendation of the Secretary of Finance. The Supreme Court ruled that the Secretary of Finance can act as agent of the Legislative Department to determine and declare the event upon which its expressed will is to take effect. His personality in such instance is in reality but a projection of that of Congress. Thus, being the agent of Congress and not of the President cannot alter or modify, nullify, or set aside the findings of the Secretary of Finance and to substitute the judgment of the former to the latter. Abacadaguru versus Executive Secretary. Truth Commission case. Facts. President Noynoy Aquino on July 30, 2001 signed executive order establishing the Philippine Truth Commission on 2010. The said truth is dedicated solely to investigating and finding out the truth concerning the reported cases of graft and corruption during the previous administration. Is the creation of the Truth Commission under the ambit of the President's power of control? Held no. No, the creation of the Truth Commission is not justified by the President's power of control. Control is essentially the power to alter or modify or nullify or set aside what a subordinate officer had done in the performance of his duties and to substitute the judgment of the former with that of the latter. Clearly, the power of control is entirely different from the power to create public office. The former is inherent in the executive, while the latter finds basis from either a valid delegation from Congress or his inherent duty to faithfully execute the laws. To Carpio, the President's power to create an ad hoc fact-finding bodies does not emanate from the President's power of control over the executive branch. The President's power of control is the power to reverse, revise, or modify decision of subordinate executive officials, or substitute his own decision for that of his subordinate, or even make the decision himself without waiting for the action of his subordinate. 15. This power of control does not involve the power to create a public office. Neither does the President's power to find facts or his broader power to execute the laws give the President the power to create a public office. The President can exercise the power to find facts or to execute the laws without creating a public office. Peralta, power of control cannot be the basis of creating the Truth Commission. Bersamin, I cannot also bring myself to accept the notion that the creation of the Truth Commission is traceable to the President's power of control over the executive power. In the case of Biragao, DPC, the Supreme Court, while it recognized that the power to conduct investigation is inherent in the power to faithfully execute laws, held that EO1 by President Noynoy Aquino creating the Truth Commission and Commission unconstitutional for being violative of the Equal Protection Clause of the Constitution. Power of supervision over LGUs. The power of the President over local governments is only one of general supervision. Article 10, Section 4 and 16. The President can only interfere in the affairs and activities of a local government unit if he finds that the latter had acted contrary to law. Judge Tadole versus COA. A law, RA 7160, Section 187, which authorizes the Secretary of Justice to review the constitutionality of legality of a tax ordinance and, if warranted, to revoke it on either or both grounds, is valid and does not confer the power of control over local government units in the Secretary of Justice, as even if the latter can set aside a tax ordinance, he cannot substitute his own judgment for that of the local government unit. Drillon versus Lim. Faithful execution clause, take care clause. The power to take care that the laws be faithfully executed makes the president a dominant figure in the administration of the government. The president shall ensure that the laws be faithfully executed. Section 17, second sentence. The law he is supposed to enforce includes the Constitution, statutes, judicial decisions, administrative rules and regulations, and municipal ordinances, as well as treaties entered into by government. This power of the President is not limited to the enforcement of acts of Congress according to their express term. The President's power includes the right and obligations growing out of the Constitution itself, international relations, and all the protection implied by the nature of the government under the Constitution. The reverse side of the power to execute the law is the duty to carry it out. The President cannot refuse to carry out a law for the simple reason that in his judgment it will not be beneficial to the people. As the Supreme Court pointed out, after all, we still live under a rule of law. It has been suggested that the President is not under obligation to enforce a law, which in his belief is unconstitutional because it would create no rights and confer no duties, being totally null and void. The better view is that it is not for him to determine the validity of a law, since this is a question exclusively addressed to the judiciary. Hence, until and unless a law is declared unconstitutional, the President has a duty to execute it regardless of his doubts on its validity. A contrary opinion would allow him not only to negate the will of legislature but also to encroach upon the prerogatives of the judiciary. Can the President create an ad hoc investigative body under the faithful execution clause? Yes. Majority of the justices in Biragao versus PTC answer this question in the affirmative. J. Mendoza, Ponente. The allocation of power in the three principal branches of government is a grant of all powers inherent in them. The President's power to conduct investigations to aid him in ensuring the faithful execution of laws, in this case, fundamental laws on public accountability and transparency, is inherent in the President's power as the chief executive. That the authority of the President to conduct investigations and to create bodies to execute this power is not explicitly mentioned in the Constitution or in statutes does not mean that he is bereft of such authority. One of the recognized powers of the President granted pursuant to this constitutionally mandated duty is the power to create ad hoc committees. This flows from the obvious need to ascertain facts and determine if laws have been faithfully executed. Thus, in Department of Health versus Camposano, the authority of the President to issue Administrative Order Number 298 creating an investigative committee to look into the administrative charges filed against the employees of the Department of Health for the anomalous purchase of medicines was upheld. It should be stressed that the purpose of allowing ad hoc investigating bodies to exist is to allow an inquiry into matters which the President is entitled to know, so that he can be properly advised and guided in the performance of his duties relative to the execution and enforcement of the laws of the land. The President's power to conduct investigations to ensure that laws are faithfully executed is well recognized. It flows from the faithful execution clause of the Constitution under Article 7, Section 17 thereof. As the chief executive, the President represents the government as a whole and sees to it that all laws are enforced by the officials and employees of his department. He has the authority to directly assume the functions of the executive department. G. Brion. Under his broad powers to execute the laws, the President can undoubtedly create ad hoc bodies for purposes of investigating reported crimes. J. Peralta. The President has the power to create ad hoc committees to investigate or inquire into matters for the guidance of the President to ensure that the laws be faithfully executed. J. Natura. I agree that the President can create an ad hoc investigative body. J. Carpio. The creation of an ad hoc finding bodies is a routine occurrence in the executive and even in the judicial branches of government. Whenever there is a complaint against a government official or employee, the department secretary, head of agency, or head of a local government unit usually creates a fact-finding body whose members are incumbent officials in the same department, agency, or local government unit. This is also true in the judiciary, where this court routinely appoints a fact-finding investigator drawn from incumbent judges or justices, or even retired judges or justices who are appointed consultants in the office of the court administrator to investigate complaints against incumbent officials or employees in the judiciary. The creation of such ad hoc investigating bodies, as well as the appointment of ad hoc investigators, does not result in the creation of a public office. In creating an ad hoc investigatory bodies or appointing ad hoc investigators, executive and judicial officials do not create public offices, but merely exercise the power inherent in their primary constitutional or statutory functions, which may be to execute the law, to exercise disciplinary authority, or both. These facts-finding bodies and investigators are not permanent bodies or functionaries, unlike public offices or their occupants. There is no separate compensation other than per diems or allowances for those designated as member of ad hoc investigating bodies or ad hoc investigators. J. Corona. Indeed, the power of control and supervision of the President includes the power to discipline, which in turn implies the power to investigate. No Congress or court can derogate from that power, but the Constitution itself may set certain limits, and the Constitution has in fact carved out preliminary investigatory aspect of the control power and allocated the same to the following: A. To Congress over presidential appointees who are impeachable officers. B. To the Supreme Court over members of the court and the personnel thereof. C. To the Ombudsman over any other public office official, employee, office, or agency. However, even as the Constitution has granted to the Ombudsman the power to investigate other public officials and employees, such power is not absolute and exclusive. Congress has the power to further define the powers of the Ombudsman and impliedly to authorize other offices to conduct such investigation over their respective officials and personnel. The Constitution has vested in Congress alone the power to grant any office concurrent jurisdiction with the Ombudsman to conduct preliminary investigation of cases of graft and corruption. Note: in this case of Birago v. PTC, the Supreme Court, while it recognizes the power to conduct investigations, is inherent in the power to faithfully execute laws, held that E01 by President Nonoy Aquino creating the Truth Commission unconstitutional for being violative of the Equal Protection Clause of the Constitution. It must be very important because it has been repeated many times.